Hi, this is Andrea Kane, and I'm here with you in HIT 330. And this is a quiz debrief, and it's specifically looking at Chapter 9. And there were several questions on Chapter 9 that it looks like we as a group struggled with. So I'm going to go through those. The first one that I noticed that we struggled with was number 5. Under the HIPAA privacy rule, when an individual asks to see his or her own information, a covered entity can provide all other PHI but deny access to psychotherapy notes. This is true. This is true. Psychotherapy notes, if you remember, are sort of super confidential or special, and so there is the right to deny access to that if there's a concern about patient self-harm, patient harm of others, those types of things. This is on page 254 in your textbook. It says under right of access, the privacy rules right of access allows an individual to inspect and obtain a copy of his or her own PHI contained within a designated record set, such as a health record. The right of access extends as long as the PHI is maintained, although the privacy rule does not require health records be retained for a specified period. There are exceptions to the right of access. For example, psychotherapy notes, which are behavioral health notes that document a mental health professional's impression from private counseling sessions, information compiled in reasonable anticipation of a civil, criminal, or administrative action or proceeding, or PHI subject to the CLIA, Clinical Lab Improvement Act. Those are all exceptions to the right of access. So, again, it says, per the privacy rule, there are times when a covered entity can deny an individual access to PHI, and these are described as follows. And one of the first ones they talk about is the PHI is in psychotherapy notes. So that's why this one is true. When you ask to see your health information or get a copy, the covered entity can provide you with everything, but they can deny you access to your psychotherapy notes. So I'm not going to credit that one, but did want to just go over it so that you have that information. Also notice the next one we struggled with is number 7. A covered entity has 30 days to respond to a patient's request for access to their PHI. Unless it is stored off-site, then they have 60 days. And let's see here where that time frame is. All right, on page 255, about halfway down the first column, the privacy rule gives individuals the right to request access to their PHI, but the covered entity, may require that request be in writing. An individual's request for review of PHI must be acted on no later than 30 days after the request is made, or 60 days if the PHI is not on site. So that is why this one is true. Number 7 is true. So I'm not going to credit that one, but again, I wanted you to know where that information is or coming from. Number 8, which of the following situations requires the patient's authorization? It was clearly giving the name of an expectant mother to a baby formula manufacturer. This has nothing to do with healthcare. First of all, giving a patient a pen, you don't have to, giving away such inexpensive items, that's not an example where you would need an authorization. Obviously, giving a sample product is not something for an authorization. Recommending acupuncture as an alternative treatment for a patient's condition, you don't need the patient's authorization just to recommend. So that's why that one was wrong. But if you're giving away the name of someone who has been with you for health care to someone who is not involved in healthcare whatsoever, you definitely need their authorization before you can do that. Okay, next one, question number 9. And going back to number 8 really quick, sorry. If you are looking at where in the book was this information about disclosing information, let's see here. Where did I see that? It sort of has to do with marketing. One of the places that you can look for number 8, it's sort of the opposite way, is table 9.2 at the top of page 264. And it doesn't fall into any of those categories. But because I can't find the specifics, on the bottom of page 271, if you look at it, it talks about marketing. It says requirements related to commercial uses, marketing, sale of information, and fundraising. The following marketing activities do not require authorization. That is, if they occur face-to-face between the covered entity and the individual, which would be recommending acupuncture or giving a sample. Concern a promotional gift of nominal value, that would be the pen situation. So it is here. It's not terribly clear. It does go on at the top of page 272 to say, unless a communication fits one of the above categories, authorization is required. And it also talks about, top of page 272, the second column, a covered entity or business associate is prohibited from selling an individual's PHI without the individual's authorization. The authorization must also state whether the individual permits the recipient of the PHI to further exchange the PHI for compensation. So it wasn't terribly clear. I guess I will credit that one back. So I will credit number 8 back if you got that one wrong. But it's something that you probably do need to know. So moving on to number 9, patients may not opt out of the facility directory. That is definitely false. You can absolutely opt out of a facility directory. And that is going to be on page 264. Patient has the opportunity to agree or object. And the first circumstance is when the healthcare organization maintains a facility directory. The covered entity must inform the patient of the information to be included in the facility directory and to whom the information may be disclosed. The patient must have the opportunity to prohibit all uses or disclosures from the facility directory or request restrictions of some of the uses and disclosures. So that's where that one came in. So 9 is pretty clear, and that one's in your book. So I'm not going to credit that one back. But yes, patients have to opt in or opt out. A covered entity has to ask those questions. Number 10, which of the following statements is true? A covered entity can choose which law to follow. That is not true. They have to follow the one that is the most stringent. So that is why that statement is false. HIPAA always preempts state law. That is not true. There are some state laws that are actually more detailed and stringent than HIPAA, and HIPAA bows to those because the state law is more stringent. State law preempts HIPAA if it is stricter. That is the true statement. The OCR, Office of Civil Rights, determines which law to follow. That's not true. The OCR follows up on breach allegations or breach reporting by the covered entity. And where would we find this? So let's go back. If you look at the bottom of page 248, where it talks about state laws and privacy, it says that the laws protecting the privacy of health information vary significantly from state to state. Some states have laws that are very specific, while others are general or even absent. Every person or organization that is subject to HIPAA, which is federal law, must abide by the state law. State laws supersede HIPAA if the state law is stricter. This is the concept of preemption, which then is discussed later in the chapter. So if the state law is stricter, that's what you have to go with. It preempts HIPAA. So that is the correct statement. And it goes on with preemption on page 249. It says the legal doctrine of preemption means that federal law may supersede state law. However, the HIPAA privacy rules only a federal floor or minimum of privacy standards, so it does not preempt and supersede stricter state statutes or other federal statutes. Stricter means that a state or federal statute provides an individual with greater privacy protections or gives individuals greater rights with respect to their PHI. If a question arises, it is important to consult with legal counsel to determine whether federal or state law prevails. So there's that information. And then at the bottom of the page, it goes on and talks about some more things that are related to that. It doesn't talk about the OCR, although I believe OCR is in this chapter. If I look in the back toward breaches, just a second. I'm not seeing it, but it's pretty clear from what I gave you that state law does preempt HIPAA if it is stricter. So let's move on to question 11. Which of the following is a patient's right under HIPAA? Does the patient have a right to decide when minimum necessary is released? No, because minimum necessary is part of HIPAA. So minimum necessary is always in play. It's not, the patient doesn't say, oh, only use minimum necessary here, only use minimum necessary there. That's not the case. It's a HIPAA rule. And let's see where it talks about minimum necessary. At the bottom of page 253, it talks about how minimum necessary standards require that uses, disclosures, and requests be limited to only the amount needed to accomplish an intended purpose. And so it's the covered entity that needs to follow minimum necessary every time. If the patient doesn't say, well, only use it here, only use it there. That's not the case. It's part of HIPAA, the privacy rule itself. So that's why this answer would be wrong. The next one, right to identify the designated record set. No, that is something that is determined by the organization. And it's already laid out that it's health records, billing records, various claim records that are used to make decisions about an individual. So that's why that one's not correct. And that is also on page 253. Right to obtain an advance directive. Absolutely, patients have that right, but it's not under HIPAA. That's not part of what HIPAA covers. So, and if you're looking at what HIPAA covers, that's really what this chapter is about, is what HIPAA covers. And you can look on page 254 for individual rights. And again, there's nothing in there about advance directive. So right to request an amendment, absolutely. Patients have that right. And that is at the bottom of page 255 going into page 256. So patients have the right for minimum necessary designated records. I mean, those are concepts, sorry. They have the right of access. If you're starting on page 254, individual rights, you have right of access, right to request amendment, right to request accounting of disclosures, right to request restrictions of PHI, right to request confidential communications, right to complain of privacy rule violations. Those are the patient's rights under HIPAA. So that's why this one is what it is. So number 15 is the next one that looks like we were struggling with. Mary Jane accesses the health insurance policy numbers of patients for billing purposes. This activity best exemplifies, well, it says nothing about authorization. Yes, she's authorized to do that based on her job, it looks like, but that's not what she's doing. She's not authorizing anything. She's not doing anything with a breach because she's doing it for billing purposes, treatment, payment, healthcare operations. She's not disclosing it. It just says she's accessing it, not disclosing it, not authorizing it, not breaching it. It's using. She's using the insurance policy numbers for billing purposes. So if you are looking at your book, let's see here. Where they give you that terminology. Disclosure is on page 274, where you can go through what disclosure is, and to some degree authorization is in there. Use on page 248. This is, I guess, where I would start. On page 248, it talks about use and disclosure. Use is how a healthcare organization avails itself of health information internally, such as a nurse reviewing a patient's health record. Disclosure is how health information is disseminated outside of a healthcare organization. So on this one, it was really a matter of knowing your definitions. 16, all of these types of disclosures are mandatory per state law, which means they happen without patient authorization, except vital statistics is absolutely mandated by law. Communicable diseases is mandated by law. Immunizations, mandated by law. And you're probably saying, where is that written in the book? So let me find that. You could use table 9.2 at the top of page 264 for this, but it also goes on page 265 under patient does not have opportunity to agree or object. And it goes through the different types of things. And that continues on all the way through page 268. But vital statistics, that is part of law, state law. So that's something that patients can't argue about. They can't tell someone you can't release that. Communicable diseases, and that's another one. These are under number 2. If you're on page 265 looking at public health activities, it says it includes vital events such as births and deaths. And they're preventing and controlling diseases. And it goes on to talk about communicable disease, when someone's been exposed or may be at risk for contracting or spreading it. And it talks about immunization records as well. What it doesn't mention is chronic diseases. It says controlling diseases, but it doesn't mention chronic diseases. And I can get where this might have been a bit challenging, so I will credit 16 back to you if you did get it wrong. But know that vital statistics, communicable diseases, immunizations, those are all part of public health activities, and those are disclosures that are mandatory. They happen without patient authorization. So question 17, no specific data element requirements for individually identifiable. The only requirement is that it must provide a reasonable basis to believe a person could be identified. This is true. So let's look at that. All right. Starting at the bottom of page 251, there's a section on protected health information, and it talks about how the privacy rule safeguards PHI. And it goes on to page 252, and it talks about individually identifiable health information. It says to be individually identifiable, the information must either identify the person or provide a reasonable basis to believe the person could be identified from the information. It does not list what that is. It doesn't, there's nothing there that says, okay, it would be your name, your address, your social security number, your date of birth. It doesn't list what it is. It just says that if you can be identified from it on a reasonable basis, then it meets individually identifiable. So that's where you would find number 17 in your book. Number 18, that was a really interesting question. Identify the individual whose medical information is no longer protected by the HIPAA privacy rule. It was 50 years. So anyone who's been deceased for 50 or more years, their information is not protected anymore. Now, I will have to say, somewhat sarcastically, that there are very few organizations that maintain 50 years of PHI. I have worked in some, and I definitely agree it's very valuable and appropriate, but it's also very expensive. And so it's a bit of a double-edged sword. Most organizations and states are not very enthusiastic about keeping records for 50 years. So this HIPAA privacy rule is sort of there for the few and far between who do respect the records and hang on to them. I worked in North Carolina, and that was a state that definitely did that. There were so many hoops to jump through that there was no way really to destroy those records. And perhaps their rules have changed in the last 5 years since I've been there, but the years that I was in North Carolina, we had records that went back into the 40s and 50s for the hospital system, the health system that I worked at. And we were definitely not able to release those, or destroy those. So anyway, the correct answer here is Charles and Roxanne, because it's 50 or more years, and so Charles and Roxanne together is the answer. And where's that 50 years? I remember talking about it in the in the slides when I did the video lecture. But let's see where it is in your book really quick. Let's see here. I'm sure they've got a section here about record retention and destruction of PHI. And if they don't, they really should. I'd be shocked. Okay, at the top of page 252, underneath individually identifiable health information, at the very bottom of that paragraph, it says, the PHI of deceased persons loses PHI status and is no longer protected by HIPAA after the individual has been deceased for more than 50 years. So they have to have been deceased for 50 or more years before it's no longer protected by the HIPAA privacy rule. And again, like I said, most places do not keep the PHI that long to where it would even be of a concern. All right, so that is it for Chapter 9. I will come back with Chapter 10 and Chapter 11 shortly. Thanks. Bye.